Good evening. Welcome to the March 2025 meeting of the Racial Disparities in the Criminal and Juvenile Justice Systems Advisory Panel. I would, if no one has an objection, like to try, particularly since we're 15 minutes late, I'd like to just try again. If people are speaking, please introduce yourself before you begin to speak. I think that will work. I'd like to try it once more, at least at this point. Announcements. Tyler will not be here. Lisa, Tyler will not be here. Rebecca will be joining us like now and then leaving at 7:30. And let's see. And Derek Miadovnik is also not present tonight. So we'll do what we can. Other than that, nothing. At the end, I want to finish up. I didn't put this on the agenda because my brain's not working. I'd like to finish up the last section of last month where we were sort of discussing changes that may in fact have to happen with this panel. So that's at the end. It won't take that long. So let us begin with the legislation subcommittee and presentation and discussion of proposed legislation regarding equity impact assessments. Who would like to start that off? Oh boy. All right. Can I at least get a sense of where that work is at?
I think I goofed because I'm not sure if I was supposed to do something, but I think I probably was. So I'm just gonna own that collective silence.
I think right now, the planet's in that space. So is that something you feel that you can do in the coming days or something? Somebody from, I mean, if it's you, Susanna. Yeah. Okay.
I guess a reminder would be helpful about what was the thing. Was it like, because my last recollection was that the representative was going to submit a short form bill. This group kind of agreed / understood that this wouldn't be moving this year, so that we would be looking at session 26 for movement on a bill, but we at least wanted it on the wall. And so we were just looking for the, 1 to 2 sentences that would form the meat of the short form bill. Is that correct?
That's exactly right.
Okay, yeah. And I mean, that couple of sentences is basically in the summary of that briefing sheet. Okay. So I don't know if the representative already has enough to go on with that, or if there's anything additional that would be needed. But I mean, I would submit that document is sufficient.
I would agree. I just know that when we looked at the draft that we were kind of using as a template for this at the last meeting, it wasn't anywhere as long as even this beautiful statement that you had written. It really was 2 sentences.
And can I jump in, Chair?
Yes, please.
I think, Susanna, it was not a one-party goof. I think the next step is to sit down with Rep. Arsenault, you, Lisa, Derek, whoever from the subcommittee, just do exactly as Eitan suggested, boil that language down, and then we can get the short form bill introduced. I think in fairness, it's also became the busy season of, the week before town meeting break, and then this week is crossover. So folks are pretty busy in the building. But I was checking in with Rep. Arsenault, who's not able to make it tonight. Oh. She is totally happy to do that work starting next find time with the subcommittee to get together with her, we can move that forward, I think, as quickly as possible.
Okay. Is that something you all feel good about scheduling now? But we can't really, can we, Todd? Because we don't know Representative Arsenault's schedule.
I'm happy to take on that piece, Susanna, just getting us scheduled. I'll reach out to Rep Arsenault tomorrow and just try and find some wiggle room. Usually Mondays are better for them. And Susanna, I owe you and Laura an email anyway, so like I'll couple those two things together, and we can work with Derek and Lisa on that as well.
Thanks,
Okay.
Todd.
All right. That's not happening. The discussion of the draft bills would be the next thing. You will recall I mailed you forwarded a packet from Laura. Thank you again, Laura. And it has like 6 bills on it. It begins with H2. None of these have, as you'll remember, titles like an act pertaining to or something like that. This one has to do with family division delinquency jurisdiction. Do you all have that? Good. Okay. So, this is the point where I think we're going to comment, each of us, or if anyone has anything, about each of these bills, because my assumption, and I have been wrong in the past, is that we're going to get to a point after crossover where they're going to call us for testimony. So it would be nice now to start putting that together, which is why I sent them out to you to read to get your feedback on them. And that's really all I have to say. So let's start with that bill, H2. Todd, can you scribble down whatever people say, please? Thank you. At this point, anything that anyone has to say about H2 would be great.
If this is helpful, Eitan, I know I can't remember the day that House Judiciary voted on this bill, but I do know that it passed in House Judiciary.
Right.
So this version, and I apologize for not following up sooner, this version of the bill might not even be the final one technically. So I can look for that final one they voted on, I mean.
Right.
But it has already passed committee, so.
I think this is still going to be good enough for us to do this particular exercise. Yeah, I thought, yeah. So, does anyone have anything about H2? Did everyone read H2? Okay. Sheila did. Oh, no, never mind. Is this then acceptable to people as is?
Eitan, I think Jessica Lee Smith has their hand raised.
Yes, I was just wondering if you could give a short synopsis of what those bills are, because we're not looking at them. All right, I'm not looking. I'm sorry.
Is someone better suited to do this than I am? I'm trying to also run.
It's okay. You don't have to. If it's a pain in the butt, I'll just listen in. I was just curious.
Well, I'm feeling guilty because giving a synopsis is not one of my better things to do.
Okay, I'm sorry. I'm sorry.
No, don't apologize. It's perfectly reasonable that you'd want to see them. If you could, Jessica, if you would email me.
Okay. I can probably just look it up while I'm in my other window or something.
Well, that's true too, but I could also forward the email message to you directly at some
Okay,
point.
thank you. I'll send you a message then.
Okay, thank you.
Thank you.
So I can briefly.
Go for it.
Okay. So H2 is one that we've been following, the office and the division have been following. I believe, and again, I apologize, and I believe the version that was sent to y'all was before the version that they actually voted on. The final version of the bill created an accountability measure for the Department for Children and Families, which was something that a lot of testimony felt like was left out. There was changes to juvenile probation, and also this included the Raise the Age initiative, which has extends out now to 2027. So it won't be moving forward on April 1st as it's currently set in legislation. It'll be paused again. And again, there's that additional accountability measure for the Department for Children and Families to establish the programming and all of the other things that have kind of been outlined in bills prior to this. So yeah.
Okay. Let me just fill in Rebecca, who's just showed up. We're going through the draft bills that I sent, and we're starting with H2, and I've asked for any commentary people have one way or another, or any way for that matter. And I'm thinking that you probably have something about this that we should know, so that if we get called, as I think we will, for testimony after crossover, we'll be able to do that. Don't mean to put you on the spot, but I just knew you would have something.
Yeah, no, thanks, Eitan, and hello, everyone. Yeah, this is of course something that this panel recommended, and I think, did you go over that already? Okay, the raise the age of juvenile jurisdiction from 10 to 12. And so
Right.
that was very good to see, consistent with what this panel wanted. There are some things that happened along the way that we were very concerned with, that is no longer in the current bill, things that were unconstitutional, frankly. Juvenile who has a couple of violations of probation could then get charged anew for the same act twice in criminal court, and that, you know, there's a small thing like double jeopardy, but that we raised that concern and that got removed. And you know, there's some other things and measures increasing the age from 19 to 20.5, 20 and a half years to allow DCF to have more time. They were saying they didn't have enough time to provide certain juveniles with enough services, and so they would age out fast enough. So that was to address that concern, and we're happy to see that. We're obviously not happy to see the implementation of legislation raising the age another 2 years delayed, but
Right.
We understand that sort of the best of series of bad options. And that's about whether or not the issue of where to place 19-year-olds. And the reason that, one of the reasons why there is a delay again for implementing legislation is that there's just no place to put 19-year-olds. We're not talking about a secure facility. There just physically isn't a place. Again, we're not supportive of the general delay again, but it is sort of our position is there's really no alternative at the moment, and we're looking to DCF to really push things along to make sure that things are ready to actually roll out, and so that we can implement this legislation.
Great. Thank you. I was pleased to see that something from our report came forward on this one. Sheila.
Good evening, everyone.
Hello.
Sheila Linton, she, her pronouns, panel member and the Root Social Justice Center. I thank you, Rebecca, so much. your explanation and just reiterating our needs as a panel and what we really worked towards and how things stand. I just wanted to keep it really real that bills like this are very challenging for me to read. With all the legalese language or the cross outs or this or that, and then the back and forth, I'm just going to be really honest. It's not my best way to take in information and be able to articulate in a way that I feel good about some of the time. So I'm struggling with some of these bills. So I think it's really helpful. I really appreciate Jessica's question, just for not only for the general public, for those of us who are on the panel, that there could be an assumption that when we're versed in reading bills and that it comes to us and understanding them. Reading them and understanding them are very two different things. And I think that I can understand things, but as we go through them as a group, it helps me to understand more and the complexities and the different viewpoints. So my point to that is I really appreciate, Rebecca, you saying what you did about this particular bill and how we've worked on it. And if we can go through the bills in sort of that way of just giving a little summary and reminding us where we did stand and what we still need to work for and the next steps. I think that it's great to hear these things, but then, okay, we have to wait 2 years. What next steps are there for this particular bill? Is there any? What do we do within these 2 years? So I think that as we go through these, we should be talking about what next steps are so we can be doing those or preparing ourselves. Thank you.
Sheila, what would make it easier for you if they were
just written in plain language without all these crossouts and like letters and like it's just ridiculous. It's just ridiculous. I don't know if anybody else, people I know you up in the bill world, and it's like that's just how it is. I understand. I read legalese all the time, but it's not it's not a good vibe, okay?
okay.
It's really not. And again, for the community, and because it comes back, like what you said, Laura, what you were saying, right? That I think it was you who's like, hey, we already passed this stuff and this isn't even the bill. And so then it feels whatever. So Rebecca's comments were valid for what we need to do, whether the bill changed or not. So that's my point. So moving forward in that format, I think would be helpful, might be a little bit more time consuming, but I think it's more productive to make sure we're all on the same page.
Okay. I did not prepare that way. I just didn't. I'm sorry. I had
And I don't think that means, Eitan, that you need to be that person. There are people who are versed in these bills, as we've seen, whether other panel members or people who are who work for the state, who I think can step up and be able to help us in this way, right?
Okay. As far as H2 is concerned, are people comfortable with what Rebecca has said? And okay. And that's what I would take forward if asked. Rebecca?
And just listening to Sheila, I would, in terms of what is the next move and suggestion, I think, again, Marshall Paul's been following this one directly. I don't know if it's been at the Senate or it's been in the House, and it's crossing over to the House side when you're going to be going over the House or not. But I think this is a comment across the board we wanted to share. On these bills that we're set to talk about tonight, we have not seen any members from the community on any of these to testify, period. So that's huge. I think on this one, although others will correct me, I don't think we've seen anyone who's not been a government member from a government agency to come talk. And then third, in terms of next steps on this particular bill, my recommendation is just to make sure that the pressure is on DCF in these next 2 years. Like, what are you doing to get ready? And that could be something where I'd be asking, I'd want to know. I'd hope our panel would want to know and ask the committee members. And then perhaps we could ask specifically from DCF periodically in between this time and the next session.
Okay.
Is there, Rebecca, with you saying that in the next steps, is there a question? Because we do have community members here watching us and engaging in with the work that we're doing. and may have the opportunity or experience to testify. Is there a certain question? Is it part of our due diligence to say like, hey, we want to put these 3 questions out to the community and let them know you may have an opportunity to testify on this as this comes forward. These are sort of the questions on this. Have you experienced this? Do you know somebody, like, how do we get people to understand the bill a little bit more information so that they can testify? That connector. And I'm wondering if that is the next step that we can form to help community, if that is a piece of what we want to do, which it is. We want community to be testifying, but if they don't know how to testify, it becomes challenging. So thinking about that.
I have an immediate reaction or response suggestion. It's something that I wouldn't be prepared to just do today. And certainly I'm not hearing you suggest that we do it today because I want to put notice on it. But if there are particular bills that we want to focus on for next session, there might be still time to get that time allowance in, and I can see if I can either, if it's Marshall who's been working on it from our side, or myself or other experts, and then other people on this panel who want to weigh in could prep and focus on just doing that, more of a deeper dive, but not so deep as to get lost in the weeds. Okay. Happy to do that.
Okay. Susanna has put in the chat, is there someone on House or Senate Judiciary or institutions committees willing to brief the group at an RDAP meeting? Or we could call a special meeting for sometime sooner than 1 month from now, so we could hear in plain language what is moving through the legislature. I could get in touch with Representative Lalonde and ask him, do people want to do that, follow that path, meet earlier than a month from now, just to go through and have these read in plain language? Rebecca.
I think that before we figure out about how soon we'll next meet, I think more critically, I'd like to hear from this group if there are any particular red flags of bills. I know we've been given a bunch tonight, I think 7, if I got the right email. Yeah. I'm not sure. I certainly have one I wanted to put on sort of the front burner. So I didn't want to, I don't think it's productive. What I'm trying to say, I don't think it's productive or efficient for us to sort of get equal treatment and time.
I'm sorry.
That I don't think that it's a great use of our time to plan a meeting within a month to get summaries of all these bills. I think that there are certain bills that should get higher focus. I just don't think I have the time to go through all of that, but I'm curious what others think.
Other opinions?
I can totally agree with that. I was thinking about my time and thinking about like, yes, I like the idea, but I don't necessarily think it's the right moment right now, and need to figure out some other things first. But in a general sense, I would like to come back to that because I think in a general sense, to have somebody come when we need them and read the bills or let us know about the bills in lay language, that sounds awesome. It's just about why, what is our goal and what are we doing? We have to figure that out and prioritize a little bit.
Okay. This was just let me put this in here. This was part of the effort that I had sort of expressed 3 years ago to Representative Lalonde, that we could get the draft bills, and there's nothing more I can say other than it hasn't happened again this session. I was deeply grateful to ORE and DRJS for what we got, because this was kind of what I had been hoping for. But if there are problems with that, we really do need to work it through, because that's a real big stumbling block. I have to say that if we've got to also schedule that in, we're going to have to figure out how to time all of this, given that this is the soonest that I could present anything to you all as a panel. So Susanna's also written. This is a good time to mention that the Agency of Human Services is hosting a 2-day conference on accessibility, and one of the sessions on 319 is on how to use plain language to make your work more accessible. Thank you.
Yeah, that was an aside. But I did just want to say I think I agree with Rebecca. I think that I would rather hear from our group, our reflections on pending legislation, before I hear from the legislators.
Okay.
Sorry, I'm eating chocolate. But I do think, I mean, I think it's helpful to hear from people in the State House what's going on. Things move they change so quickly, especially now after crossover. So it may be difficult to get a point in time assessment of what's happening in there. I will say, I mean, we are happy to continue kind of sharing what we are mapping. And actually, Laura and our policy analyst, Angela, have very helpfully created what we're referring to as a map that I think may be useful for this group. Laura, I don't think that's what we sent over, right? We sent over kind of the list before, but not the map.
Yeah, no, we haven't shared that with anybody. The map.
So what I asked the team to do was to take the legislation that's pending that has to do with the justice system generally, and to map it out in a way that aligns with the stages of how people move through the system. So which bills over here that have to do with like pre-entry into the system, and then over here the ones that have to do with like adjudication, and then sentencing and community reintegration. And that way we can kind of see the spread of what parts of the system legislation is focusing more on. It's very rudimentary. Right now we have this in an Excel spreadsheet, so you're not going to get something tremendously elaborate, but visually I found it helpful. And so that's the kind of thing that we've been doing internally. If this group is interested, we'd be happy to continue to share those updates. But I also recognize that I don't want this space to be dominated too much by ORE's input. It's a really important mix of entities represented here. And so we would like to be as useful to this group as you all would like, without drowning, the space.
Thank you. I have to say I was grateful. I mean, I just wanted to see some draft bills, and I was very grateful that you guys sent them. I did not give thought to a dominance of ORE or DRJS or anything of that sort. I was just extremely grateful after 3 years that finally I had something to hand out to the panel so people could read it and come back with comments that would be useful for testimonies. So what do people think? What is that? Are people concerned about there being too much presence of ORE and DRJS? Should I have waited for Martin Lalonde? Should I have figured out something completely different from what I've done? I need some feedback, folks, because at the moment I'm just like working on what I've been working on, which is my own thoughts. And that's clearly not been useful. Rebecca.
No, I appreciate anyone on this panel providing some assistance and giving us some leads on this. I know I'm speaking for myself, but I don't think I'm alone. Just as just buried, feeling buried, right? So I appreciate that. I don't feel like it's dominating. I do have another bill that's recently hit my radar I'd like to add to this group. It's the nature of this, as Susanna said, of this quickly changing environment, since we're not given the support that we've been repeatedly asking from our legislative leadership to give us a heads up. I feel like sort of organic and a little bit ad hoc, and we have to be flexible and nimble during this time. It's sort of the nature, but I don't mean to shut down other people's suggestions. I'm just wanting to say I am okay, more than okay. I appreciate this meeting agenda today.
But it's not working for some of us, right? I mean, it's not working for Sheila, for instance, as she in a very lovely way, told us what her problems are with looking at these. And so, did I take that into account? No, I was so monomaniacal. I was so glad I had bills after 3 years that I just went with it, for which I apologize. But I need to hear back from people about what they want to do right now. Do people not want to comment on these draft bills that are here?
I would like to move forward with us commenting on the bills that are here. So I didn't want my comments or my access needs to get in the way of us moving forward. I'm just saying it's much more challenging for me and time consuming, and it's useful and helpful for me to hear other people, because maybe I understood something one way, and then when I hear somebody else talk about it, maybe it helps me understand it a different way or a correct way. Not really sure. But so we can move. I would love to move forward and hear people's comments on the various bills.
Okay. Thank you. So can we move just in order that they were sent out? So that would mean we're now on H32. The subject is corrections, human services, substance use disorder, medication for opioid use disorder. Anything from anyone about H32? If there were a call tomorrow to testify on this from the RDAP, would everyone be comfortable with my saying that the RDAP is comfortable with this bill? Okay. A shaking head means I need to know why. Thank you, Rebecca.
Well, I can't share our opinion on this. We haven't had a chance to review it. And so I knew this was on, but we just haven't had a chance to take a look at what this is. This is about sort of, I think, trying to encourage better. I mean, the concept sounds good. This is about memorandum of understanding between DOC and opioid treatment programs to try to facilitate the provision of medication related to opioid use. And we just haven't had a chance to compare what this is proposing that is not happening right now. And so I'm just not in a position to share. Okay. So I think my recommendation is or certainly I'm not on this panel able to say whether we support this or not.
Okay. It seemed to me to be about writing memorandums of understanding more than anything at this point. But others?
It does sound benign. Sorry, Tom, to jump in. It does sound benign. It just is not clear to us how this is changing current practice.
Mm-hmm.
What is the problem that's being sought to be solved by the MOU? That's
understood.
That's
okay. And that may be the thing that would be said tomorrow. Sheila likes it. Okay. Anything from anybody else?
Aton, Lisa Ryan,
yes.
she, her pronouns, Vermont Criminal Justice Council. I see Laura put continuing of care for opioid use disorder upon release. Sorry for my naivety, but is that folks currently get treatment while they're under the Department of Correction supervision? And so we're at this bill is supporting that to continue upon release.
Yes.
Yes.
From my understanding of the bill, that is one of the major things. And then what Rebecca said about entering into MOUs and other things and having those kind of agreements. And I think specifically it mentions like a hub and spoke model to kind of reflect what's already being used in the community. And then I just added this in the chat as well, that House Corrections and Institutions isn't really likely doing much more with this bill until the 2026 part of the session, because there's a lot of funky stuff with the language that I know Chair Emmons didn't want to just like push through, especially operationally with different requirements on the Department of Corrections ends to actually like implement something like this. So the last bit of testimony that our office and division reviewed on this, basically the Department of Corrections and the committee members who proposed this bill, as well as Ledge Council, are working on kind of tweaking that language.
Thank you, Laura. Really helpful. Thank you.
No problem.
Todd.
I have not read H32, but just from my prior experience at AHS, what I would posit, and Laura, certainly you have good experience in this space too. One of the challenges so roughly half of the incarcerated population is on MOUD, medicated assisted opioid use disorder treatment. And one of the challenges when folks transition out of incarceration is hooking them up with continued treatment. And I want to be a little thoughtful. We use the term treatment. This is not recovery planning. This is pure medication to limit withdrawal symptoms. There is very little additional support for individuals in an incarcerated setting in terms of moving on a path towards recovery. The goal has been, and I would anticipate still is, to help smooth or create a better path when individuals leave incarceration. Otherwise, they're very likely to fall back into active substance use disorder without further support. So some of that, I assume some of the MOU stuff, Rebecca, is really tied into like connecting to Turning Point. Some of the other, especially folks with lived experience, substance use disorder treatment providers, not so much just getting the methadone or buprenorphine or whatever the actual substance is, but moving into that space of like, how do you go towards recovery and a long-term path? So again, pure editorial. I don't have a lot of direct knowledge of that, but structurally, that would be my guess as to what they're trying to do.
Thank you.
Laura summed that up as continuity of care, which is exactly that.
I didn't even read that. The part about that they just get drugs. I didn't read that.
Yeah.
That's a real problem. I mean, we know that there has to be counseling. I mean, this is not rocket science. It's also not new or a radical thing to say. There's a lot of research on this. So I don't know. I would think right. Anthony Jackson Miller just put in, what if long-term isn't quitting, but reduced use? What about mental health supports? And that's kind of where I was going, was with the mental health supports that would seem to be absolutely necessary. But Jessica?
Yes, I was just going to say that I understand and I want to be open to all different ways of getting through that with addiction. But with people in my family that were addicts, I was taught that was a form of enabling. If you're giving them a different way of using drugs or putting them on a different kind of drugs, and you're just getting them sort of addicted to other drugs. And the goal is getting them free of drugs. So it's like, if you're just giving them drugs or making it easier, it's like you're torn between two places, just like you would be if it was a loved one. You don't want to enable them, but you also don't want to make it hard for them. Maybe just making ways of making withdrawal much more humane, like sedation withdrawal. And also making, if you have to go into a rehab, I know my brother was very concerned about that. That's why he didn't do it, was because it would have been reported to his business, and he worked for Goldman Sachs. So he didn't want to lose his job, so that would have been known by everyone in the company. So he never went. So I would say privacy and also sedation, withdrawal, but somehow getting, if you're just giving them that, how are you going to get off of it? I mean, you're torn. I just wanted to make a point of saying that, enabling.
Okay. Thank you. Todd, would you note that, please? Thank you. Thank you. All right. So that's what we've got on H32 at this point. And so I guess we'll just leave that here right now, unless somebody else has something else to say about it. Okay, let's move on then. Give me a moment. This damn thing
Hey,
just
Tom, I'm
keeps
just wondering
turning.
if this is Sheila. I'm just wondering if there are next steps for the bill, if anybody has any, after people have talked, if there's any next steps that we should be taking.
I don't think there are any that we can take. It's in play right now with the legislature. There's nothing. I mean, I suppose we could talk with individual legislators, but that's going to also mean that someone's going to have the time to do that up in Montpelier.
Got you.
Rebecca.
I just wanted to share, you can look up the status of each bill, and I just looked up the status. And if others see something different or interpreting otherwise, it looks like it's been sent to corrections and institutions early January. It's not clear to me there's been any testimony taken. Oh, no.
There has been testimony taken on it. I just know that they're in the process of like updating the language, because DOC was not involved in the drafting of the bill, which was mentioned in early testimony. So I don't like that. So it was kind of clear to me from the beginning that Chair Emmons didn't really want to do much with it until the 2026 half of the session, because the language is so incorrect as far as like being able to even be implemented on the Department of Corrections side. So now they're working together with Legislative Council to kind of like address all of that. So to Eitan's point, I don't think there's much we can do other than be aware that it exists and then keep our eyes peeled.
Okay. Great. Thank you. Then H118, which is all related to an act relating to expanding the scope of hate-motivated crimes. And the reason I'm quiet right now is I'm waiting to hear from the panel.
Todd helpfully gave us the motivation and the intent behind that at a previous meeting.
Right.
I'm happy to restate it for other folks.
Go ahead.
So the goal here was to move our current hate crimes enhancement statute solely focused on an individual victim. And that meant that when there was a hate motivated action that may have been taken as a means of attacking a group, but it was, say, spray paint on a public facility, the stealing of a flag from a school, because the victim of the crime itself, the property crime, was not an individual of a protected group, there couldn't be a hate crime enhancement, even if it was very clearly hate motivated. And so the small tweak that has been added, and this bill has passed the House and is awaiting to be taken up in the Senate after crossover, would simply enable local prosecutors to add those hate crime enhancements to crimes that otherwise at this point are really focused on attacking a group, not an individual.
Thank you. Jessica?
I really like that idea, what he just proposed. I really like that idea, differentiating that. And also, I would just say, I know it's a broad statement, but with hate crimes as it goes, that always borders on where people will say maybe it's protected by the, the freedom of speech thing. But I think when it comes to certain hate speech, when it comes to certain groups where it becomes dangerous, then it should not be protected by that freedom of speech. I don't know if that's what we're discussing, but hate crime wise, I think we have to be very careful because it's rising very fast and it happens just like that, violence and stuff. Thank you.
Thank you. Anybody else? Rebecca?
I'm sharing the Defender General's position on this. We have testified in opposition to this bill, and I'll share the reasons why briefly. And I understand Jessica's concerns, and our position is not because we tolerate hate crimes and racism. In fact, we absolutely do not. But our position is that throwing more incarceration at hate, at racism, actually doesn't get to solve the problem. Our concern is that, and it's a position we take for many other proposed crimes or proposals to increase penalties by way of incarceration, there's no rehabilitation behind bars. And when you throw people into jail who are exposed to more, who are disenfranchised and taking them more away from being able to reintegrate into communities, we believe that this will actually exacerbate the problem, that it will make people more racist and more hateful. But on a legal front, it was raised about the First Amendment concerns. We believe this is unconstitutional. We testified as to that. There are absolutely entire categories of unprotected speech. So not everything is protected under the First Amendment. Fighting words, incitement, certain long historically recognized categories. Even within the categories of unprotected speech, the U.S. Supreme Court has held, so it's controlling law, that you can't discriminate on the context of speech within unprotected categories of speech, and that's RAV, the City of St. Paul. And so, on the other hand, there was a review of something where there was a sentencing enhancement penalty based on a hate-motivated crime that was upheld as not violating the First Amendment. That's Wisconsin v. Mitchell. And so the question is, does this law fall within more like RAV or Wisconsin v. Mitchell? And so without getting too deep into the weeds, our position is that it actually is not constitutional for the very fact that it's not about targeting a particular individual, that making it so that it's a crime and enhanced penalty just generally applied without any specific person targeted makes it, in fact, crosses the line into First Amendment violation territory. So we expect this to be litigated, which is also not an efficient way to go about dealing with a solution. And so that's our position.
Okay, thanks for that. Anybody else?
This is why I like people talking, because that was very interesting. That was not that. Thank you, Rebecca. That was okay. Now, see, lots of thoughts, things to think about. The one point that I did think of and that I do agree with is the incarceration part. As a person, I'm TMI right now, who's been a part of a hate crime and have advocated for that person not to be imprisoned or jailed for the crime, but to go through other reparative processes. I believe in that piece and what you're saying. The other stuff, very interesting, and I'll have to understand and think about that more. But what I was really curious about, and I know this is probably not the subject of the bill, but I was curious about the fines and who actually gets that money. And because I know, like, oh, they got the victims advocate, the victims, whatever unit, whatever, you get a little bit of money if somebody jacks you up, maybe, or whatever. But then the rest of the money goes where, to whom, why? And I'm wondering when it's not, I guess this is more about a group. So, but does that, yeah, I'm just sort of curious about how that works because what I've experienced is that you don't get made whole again. And so does that money go toward actual fine? Does it go towards repairing that graffiti on the building? Does it go in that pocket of the persons that you beat up? Does like I'm a little curious about that piece around bills and this one in particular.
That's fair. That sounds like something that we should bring up. Todd, do you have that? No. Okay.
I mean, I believe as it stands, all fines and fees go to the judiciary. There may be restitution paid as part of part of plea bargaining, or other sort of non-criminal justice resolution, sort of formal criminal justice resolution. And restitution can be ordered through that process as well. But Farzana may, not to call her out, but having, an experienced criminal prosecutor, she would have probably hands closer to this one than others, but I would leave it up to her if she's able to jump in.
Yeah, no. So in terms of victims advocate services, they usually are the ones that would collect the money from the defendants. So if there's a conviction, they then would, I think, reimburse the victims if there's restitution, and then they would collect from the defendants the money. Does that make sense? So in terms of restitution.
Sheila, did that work for you?
I mean, it didn't work for me. And I don't know because it's not streamlined like that. And so there's lots of, yes, I understand that is a piece to the spokes in the wheel, but it's more complex than that. And that's what I'm talking about is the other complexities and understanding, is it because, oh, we represent and we use court services, so they get some money back? Or like I'm trying to really understand because I understand that, yes, the SAVA, all those people, I understand that process, but it's not necessarily like a dollar for dollar. It's not that kind of situation usually. And so I'm just wondering when we say the fines and restitution are very different things. So the fines, like you said, I believe, Lisa, was going to the judicial. And so if that is the case, there's this totally separate conversation of restitution and all of that. And I don't want to get mixed up with those things because that's not what it says in the bill. It doesn't talk about restitution, it talks about the fines. And so I'm talking about the fines. So I want us to stay focused. So no, it doesn't work for me.
Oh yeah. So the fines generally goes to the judiciary.
So I want to understand what that's really for, because it seems like for a person, like if a person entity went through a hate crime, it feels like the system's profiting off of that. That's all I'm going to say. And there's how do you make the other person entity whole in that? And I understand that's where y'all come in and whatever, but there's some wishy-washy about that.
So I could look into that for you, Sheila, and I can email you. Would that work?
That'd be great. Thank you.
Yeah, no worries.
Cool. Okay. Shall we move on to the next one? People, at least nod your head or something. I feel like I'm talking to toasters. Thank you. That would be H14. And this has to do with the use of animals in product testing. Laura, where was the racial component in this one?
This was one that came up, and I'm not trying to put you on the spot, Susanna, but I believe we included that based on our policy analyst suggestion and the work that they have done.
Okay.
I sent you everything that we mentioned in the meeting. So
okay. Thank you. I just wanted to hear, I mean, I can be talked into many things, as you well know. So I didn't want to immediately say anything about this, but I was sort of curious as to whether this was even in our purview. And since you all had pulled it out, I figured I was missing something.
Again, I'm going to default to Susanna on this one.
Okay. Okay. Susanna, do you have anything on that you could, because I don't want to go into, just because I don't get it doesn't mean anything.
I feel like maybe Susanna has stepped away for a moment because she's
okay.
had her camera on and it's off now.
Okay.
So maybe we could come back to this.
Okay, we'll come back to it. All right. Then we are on to, oh boy. An act, it is concerned with an act relating to after hours access to orders against sexual assault. You see it? You have those that packet that I sent you? Okay. Same exercise.
I'm happy to kick it off.
Go for it.
There are many of these laws allowing for after hours applications for a restraining order for various types of offenses or concerns. Sexual assault is this one, stalking, relief from domestic abuse. It's hard to find all of them. I wish that were sort of that could be helpful, but our position is no objection, no concern.
I'm sorry, say that last.
Oh, our position is that we don't have any objection or concern.
Okay. I didn't see anything personally, but that, again, that's me. Everybody else?
Likewise.
We need after hours. That's what I was going to say. Sorry.
No, I apologize, Jessica. Likewise, the AG's office has supported this as an expanded opportunity for victims and survivors of domestic violence to get relief.
Okay. All right. Thank you, Sheila. Okay. Let us go back now. Susanna, there was some question while you were away about H14, about the animal welfare bill. And I was curious. Go ahead.
Sorry, why it was on the list? Is that what you were going to say? It was on the list because it creates a penalty, and we're including anything that creates penalties or things like that.
Thank you. All right.
I'm sorry. Can I jump in?
Yeah.
Susanna, what does that mean?
It criminalizes or enhances the penalty for treatment of animals. And so things that are about the justice system or that create new crimes or modify the punishments for existing crimes.
Got it.
We have tended to group those together for the group.
Okay.
Thank you.
Thank you.
Thank you.
So now, are there comments on that one? As people have read through it and now have been further enlightened. No. Okay. This will be another one that if I got magically called 5 minutes after our meeting this evening, that the RDAP has no objection.
I had a question.
Good.
I didn't thoroughly read this one, so transparently, but I'm Sort of curious if in this bill, because when you first brought before Susanna told us what it was, why it was included, I was thinking, well, does any of these animals represent in any specific, tribe or culture an indigenous animal and that they use for whatever? And so I'm wondering if I don't know if that's a factor or an endangered species or anything like that. I don't, because again, I'm very ignorant to what the whole bill says, but it just made me think of, looking at the bill in that lens. And it made me think of, as a Black person, where they've tested things on us as Black people and still continue to do that to this day, I'm convinced. I do have some feelings around the testing around animals and what animals do they choose and how is that associated to human life. So I just have other questions surrounding this bill. I don't want to complicate and make things complex and like weird out on some nerdy stuff right now, but I'm thinking about this on a more I don't know, a more indigenous perspective.
It's worth bringing up, absolutely. I mean, why not? Rebecca, 1 minute. Let me get Jessica. She had her hand up first. Jessica?
Yes. I was just going to say that I think when it comes to animals, I understand how it came up in this context, but usually when somebody is harming an animal, it does say something about their ability to, be vulnerable to coming off with violence and stuff like that. It says something about their mental state. And, it's not a good sign if you're harming an animal. I'm sorry.
Let me just point out here, this has to do with animals being used in testing. It's very specific.
I thought she said I thought Susanna said when it came to the fines and stuff, something to do with, yeah. Thank you.
Thank you. Rebecca?
I just wanted to share that we haven't had a chance to look at this. I am taking Susanna's point to heart, which I appreciate you putting this on our radar and explaining that it's creating a new violation. I'm trying to find right now what is the penalty. And I think that Eitan, since we haven't had a chance to look at it, because it creates a new, I don't know if it's
a new penalty.
Yes, that certainly I can't support a default position of supporting it, is my point. And I think that I just would recommend that if you get called asking for our opinion, that it be instead insufficient information to support or not support.
Great. Thank you. That's it. Okay. I'm just trying to mine that from everybody. Is there any other objection to this? Jessica? Jessica?
No, I hadn't lowered my hand. I'm sorry.
Okay. Okay. All right. Then S12, introduced by Senator Hashim. This is the one about sealing and expungement and so forth. You remember? We've been talking about this sort of on and off for 2 sessions now. I mean, the idea of sealing and expungement. The government has gone back and forth on this. There are people who feel very passionately about either options, sealing or expungement. I think this is an important one for us to weigh in on. I think it's actually critical. I mean, I personally have issues with the sealing only because sometimes, how to put it, I don't trust anybody when they tell me it's sealed. They tend to be able to find a way to not keep it sealed. in other places I have been with which I have been involved. So I'm a little concerned about that. That's my thing. What's your things? Jessica?
I'm sorry. Okay, I was going to say I agree with you, Itan, about the ceiling. Usually I've seen, in certain cases, maybe it's not the case in all the cases, but in some of the cases, it works. The ceiling thing works in favor of somebody who's trying to keep something from somebody who may need that information.
Mm-hmm.
I like the idea of expungement, of course, if it's something that was wrongly put on there or something. But when it comes to certain crimes, I don't know if I might do sealing when it comes to sexual crimes or child crimes or things like that. Thank you.
Those crimes are listed as ones that wouldn't be allowed for that, which is good. And I would have to add that I think I agree with a lot of this. Like, for example, if you're a young man, you do a lot of stupid things that shouldn't be held over your head indefinitely, especially since young men, our brains don't fully develop until we're 27. So it does seem silly for you to be able to not have opportunity or a chance to make right.
Okay.
He's right.
Rebecca.
So it's true. There seems to be a bill related to sealing and expungement every session for the past several years. This bill is the most extreme, that version, and in a most concerning way. And so we have repeatedly tested. I think we certainly have testified once and have expressed our very strong opposition to it. It's certainly more extreme than the version last year. And so what I wanted to share is, yes, we currently have an expungement and sealing statutory scheme. And as people have talked about the difference, there's a significant difference, right? Expungement makes it so the entire record is gone after certain qualifying events. A judgment of acquittal, someone is found not guilty. A court dismisses a prosecution with prejudice. A case is dismissed without prejudice, but the statute of limitations have run. There's a lot of different categories where a criminal record can get expunged, which means it's eliminated from the court record, except that there is what's called a special index maintained by the judiciary, so that if the person who was the defendant at issue ever needed something related to that old conviction, proof that it was that they were acquitted, proof that there was dismissed with prejudice, they could get that certified copy from the court. So that is the one exception. Sealing is something different, and it isn't expunged. It allows for certain law enforcement personnel to access it. That's a term of art that's defined by statute. This bill, I believe, or it's already expansively broad. It's an incredibly broad definition. Our concern is that it opens up for many, many people to get access to a sealed record. It also eliminates expungement as a concept, period, except for in deferred sentences. And so that's extraordinary rollback of where we are currently, where the jurisdictions are elsewhere. So I don't understand the motivation for this. I think actually my understanding is that there is a concern to collect data on successful cases. In terms of success, I should be clear, where cases have been dismissed by way of judgments of acquittal or dismissals with prejudice that would then be expunged. There's concern that that data is no longer available to be tracked, but that's not correct. And again, as others have talked about today, expungement is critical for moving on, right? To being able to leave behind and not have the collateral consequences that comes along with a criminal charge, a criminal conviction. And I think this bill has direct implications and interest for this panel, because we've heard in other sessions about the disproportionate number of Black people in Vermont who are getting charged, right? They're getting charged with crimes. Then if they are not allowed to be having their records expunged, then they're disproportionately affected by that. I understand that this has been through Judiciary Committee. It is expected to move out of there soon. If not, I don't know when. Our position has been made clear, but I think there is no indication that there's going to be amendment to that in the Senate Judiciary. I understand that there's been no input from community members or impacted persons who've been, trying to get their lives righted after a criminal case. So there's just not been any voices heard from Senate Judiciary. I find this to be particularly appalling, considering we've asked for such input. So just
yeah, this is remarkable. Laura, go ahead.
I just had a question just for Rebecca, because I know this was one thing I followed this bill really closely and watched a lot of the testimony on this. And I can't remember because if I'm remembering correctly, one of your office's concerns was about the deferred sentencing and them taking away expungement for deferred sentencing. So is that still in the bill, or did Senate Judiciary take that out? Because I can't remember. So I'm just curious really to know if you know.
I think she had to go.
sorry.
No, there she is. Okay, never mind.
I do have to go. Thank you for reminding me. I'm sorry. I have childcare duties that are pulling me. I think that's still in there, Laura. That's the one exception for expungements. Allowed is for deferred sentences.
Okay, I couldn't remember if they had taken, because initially they were going to take that out and do some kind of retroactivity, but then I know, so I just wasn't sure. So I'm glad to hear that they're leaving it the way that it is.
And that's my understanding at the moment, but.
Okay, thank you.
Okay.
Can I just jump in? Nathan?
Yes, Todd.
So, and I apologize that Rebecca is going to bounce out as I talk about this, but the Attorney General's office supports the changes in this. We run expungement clinics and have for maybe 6 or 8 years around the state. And part of the motivation for changing the expungement regime to a ceiling regime is actually to expand the number of crimes. And sort of the trade-off here is, do you move away from an expungement path? And expungement was only available for a pretty narrow set of misdemeanors, by and large, with maybe 2 felonies thrown in there. And versus ceiling, which was available for a whole broader sweep of crimes, including, and it's still the case, though we haven't raised this in testimony because we don't want it to actually come up, almost any crime committed before you turn 25 is and remains sealable. And the trade-off has been, can we expand the number of crimes that can fit into a ceiling regime and ensure that the ceiling regime has some guardrails around it in terms of use, while at the same time recognizing, and the example that comes up a lot is if you have a cold case and you get a tip and you've got a record out there that provides somebody's address and you're able to connect some forensic evidence with a file, and it gets you to rescue the individual who's been kidnapped or otherwise, should the state just ignore that evidence? Should law enforcement sort of turn away from that? Our testimony has largely focused on the rehabilitative aspect. I think it is unfortunate that there haven't been more individuals who've taken advantage of expungement and sealing coming in. We have a whole host of individuals who have reached out to our office, either working with us to get expunged records or sealed records or otherwise. And I think, I won't opine on why that hasn't happened in Senate Judiciary. I anticipate much more opportunity for that happening in House Judiciary, assuming it passes the Senate this week. But I would just say candidly, I think it is a very fair critique that this is a rollback of a protection that Vermont has provided individuals. And Vermont was out in front on this, and the rest of the country hasn't followed along where Vermont is in terms of expungement. Most of the rest of the country does sealing. I also was looking, I haven't caught up with the latest iteration of it. There was, and I would trust Rebecca's review of this, but I'll go back and look at it too. there was automatic expungement for any dismissed cases or cases where one was acquitted or judged not guilty. And so there still are certain categories, but what would roll back, and I think it is important to contemplate, is that ability to say, hey, I committed this crime, you know, to Dan's point about youthful indiscretion, right? Like, I committed the crime a long time ago, you know, I've aged. I mean, the stories we get, and it's, I'm sure the law enforcement folks know this, and prosecutors as well. The age curve is going back to age 2, really remarkable when you watch when people have committed criminal offenses and how quickly after age 25 into age 30, they go to almost nothing again. And so I think there's a lot of value in having people be able to move past those youthful indiscretions. Again, our view has been more crimes being sealed is better than few crimes being expunged.
More crimes.
I'm not going to capture much of that in the minutes.
Okay. Anything else people have on this? Because it's also clear, I mean, that we need to talk a lot more again about sealing and expungement. But I do think that the idea that the fact that this is a rollback is significant, should be raised to the legislature. I mean, my question would be why? Why the rollback? What has happened that occasions those concerns? Is it an example of advanced compliance? I don't know. Sheila.
Thanks, Eitan. I had the same exact question as to the why. I totally agree with what Rebecca was saying. I think what I heard Todd just saying was that they still want to be up in people's business and not have that protection in order to maybe protect somebody else, is basically what was just said, if I heard it correctly. I just want to remind us that, you know, all of that can sound nice. Like, it's like, oh, yeah, okay, yeah, there's a crime out there and it's sealed, you know, all that can sound nice. But we have to remind ourselves why we're on this panel, and that's for disparities with racial disparities. And that's why we're talking about that.
Right.
Okay, so if it was to just be like, oh, you know, everything was like not racist, then we would be able to have that conversation that Todd explained. But the fact that that isn't what the reality of the world that we're living in,
Right.
that means that disproportionately those people who are being sealed, let's say disproportionately are people of color, which will ultimately disproportionately mean X, Y, and Z. So not cool, not down with it at all. Do not agree with it, and I'm really upset that this has rolled back. And to take away that option of that expungement, and I hear that, of course, there's all these caveats. There's always caveats. And what's interesting about those caveats is that I find that people of color often fall into those caveats of where they can't get what they need done. Like, they can't get that expungement. Oh, you don't fall into that. You don't this. And we run an expungement clinic as well. And so that's focuses and centers on BIPOC people. So we're aware of some of those needs and things. And so I just feel really strongly that this is definitely a rollback, that it's going to actually create more racial disparities, and that this is in favor of the system.
Okay. Thank you. Thank you. All right. S23. This was an interesting one. I had fun reading this because I wasn't even sure what I was reading at a certain point. The subject is elections, right? Preserving the purity of elections. Right. In fact, it is about offenses against the purity of elections. And it's about synthetic media. Now, that I have to say, I had no idea what the hell people were talking about. The hell is synthetic media? It's all synthetic.
This came out of the AI Advisory Council. It's one of the recommendations from that group. And basically, it's about the use of AI to develop deceptive political ads.
Okay. Okay. I mean, I saw it. Okay. I just wasn't sure because I'm old, what synthetic media meant. It all
Deep fakes.
synthetic. Okay.
Deep fakes. I'm almost certain it came out of the AI group. I could. Sorry, I could be wrong. Todd, you're in that space too. Am I remembering this right?
Yeah, I don't remember that either, honestly, but I know the Secretary of State's office has pushed it because Vermont is becoming a minority state in not requiring at least disclosures around the use of synthetic media.
Okay.
Okay, that might have been where it came from.
Okay. Well, this is one that I personally would have to reread because I totally screwed this up. But maybe you all had a better luck with synthetic media than I did. I even Googled it. I was like, what the hell? It wasn't helpful.
Can somebody talk about the racial disparity that's within here?
Anyone from DRJS, ORE?
Well,
okay.
I think when we aggregated it, it wasn't necessarily with the lens that we know that this will create a racial disparity. But the idea behind it, of course, is that, whenever you're thinking about creating new violations or penalties for them, there's always the risk that they'll be, imbalanced in their application and enforcement. So I think just keeping an eye on that is important. I guess, we could also talk about, like who's more likely to consume certain forms of media, who's more susceptible to being the victim of quote unquote synthetic media, and how likely are they to get recourse if something like that happens? What's the risk that it happens to your identity, reputation? All of those are going to carry downstream racial disparities. But I think in this case, this is just included in the list for awareness about a new thing that's happening that now we have to worry about. It's not just crimes, quote unquote, but crimes, quote unquote, with AI.
Okay. This was one I think that they're not going to call us on immediately, but I could push it. No? Okay.
I don't see it. I think they'd call in the AI council before they called on the RDAP.
Okay. All right. And that's it. That's it. That's all that's on the list. Okay. Oh, sorry. I was reading the chat. There's too many stimuli. I think it would be helpful if people, after this discussion this evening, went back and looked at these again and emailed things to me. I will create a master sheet of comments. Should anybody email me, I will create a master sheet of comments and then get that back out to use that as a basis for a discussion further down the line. Okay? Sound good? Okay. Give me a second here. We are up to public commentary. Mark.
Oh, hi there.
Hi, Mark.
Grace, you want to go ahead?
Yeah, maybe sort of before public commentary, the Racial Justice Statistics Advisory Council is supposed to do a report to RDAP
Yes.
once a month. So this is the first of those, which will be very brief because I'm here. I'm the co-chair of the Racial Justice Statistics Advisory Council and the Vermont Racial Justice Alliance appointee on that committee.
Welcome.
Hi. I can put my camera on, sorry. I was just like sitting here listening. So mostly I'm here just to like try to start to make a habit of this because it's our first time to come to you and make a report, and then we will do that, and you can figure out how you want to work that in. It'll be probably very reports. So what we've heard the last couple months is we heard from the division a few challenges on traffic stop data, in particular about problems with data, which I'm sure that you've heard a lot about also with missingness, suppressed data, like systems that don't talk to each other. And then in our March meeting, we also heard from the division on some challenges on the harassment, hazing, and bullying data and the difficulties in getting those data points from the schools. And we heard some public comment from Reverend Hughes talked to us about H 382, the Vermont Justice Transparency Act. And we didn't even have a quorum at our March meeting. So we will be discussing that together, for our April meeting, just to put that on your radar, that like that's on our radar. And then I'm hoping to look at kind of the RDAP recommendations on high discretion, high impact data points, and how that particular piece of legislation lines up with that and satisfies it or not. But that's all discussion that is to happen next time. And that's about what I have for an update.
Great.
Introduction to us now being, we'll hopefully be giving you some reports moving forward.
Fine. Grace, would you like me to send you the mailing list so that you can mail it out, or do you want to mail it to me and I'll just do it? Like, that's what I usually do, but it's
either way, it's fine with me. I can
mail it to me and I'll do it. That's fine.
Great.
That's fine. And I mean, it's an open meeting, right? It's a warned open meeting, so people can come and sit and listen. So
we offer public comment at the end of our meetings. So
some RDAP people may want to come, like myself, but okay. Great. Yeah. Thank you.
Yeah, thanks.
Grace, when are those meetings?
It's the Friday before this meeting. So it's the first Friday.
First Friday.
At 3 p.m.
Thank you.
Yes.
Thank you. Any other questions from anyone? No. Mark?
Yes, sir. Good evening.
Good evening.
I wanted to just lift up the H 382 to this body, particularly in light of the work that I just saw you doing here. This probably should have been included in your list, but it only came out just, you see how high the number is. It came out like 15 minutes ago. No, it came out right before town meeting day. So you may have missed it as a result of that. Introduced by our illustrious, industrious Kevin Coach Christie. And it's, if you recall, the policy that was introduced probably a few years ago, and I think it was introduced as H-184 in 2019. This bill is verbatim, and it seeks to collect disaggregated data across much of the remainder of the criminal justice system. So I just wanted to ask your consideration for if you would want to go in and offer some testimony on that, and compel them to pull it off the wall, understanding that it's probably going to be next year, given all the things and where we are right now in this session.
Okay.
I'd say that other things that might be of interest to this group might be the Equal Protection Constitutional Amendment at least on some level.
Right.
I know that the that's PR4. It's probably hidden in rules right now, and it's I would imagine that after the money bills cross over next week, we'd want to probably start advocating for that because there are no restrictions on crossover for constitutional amendments.
Right.
And I'd say that I'll just flag a couple of other things just so you can maybe scribble them down if you care to. Is
Mark, can I ask you if you could put them in the chat after you talk about them?
Of course I can. I'm happy to do that.
Thank you.
So one of them would be an act relating to promoting racial and economic justice, and that is H 451. This is the third consecutive biennium we've introduced this policy almost verbatim. The next one would be, I may as well just share, it's just probably about maybe 4 or 5 more, okay? There's one that we're referring to as a pilot program, establishing a community health center pilot program, which is a little bit misleading, and that is in H 184.
Okay.
So you should see that one there.
Yep.
And then there's let's see, there's another one that, and these are they may not all be necessarily completely related, but those social determinants are entangled. We're calling the constitutional and accountable policing bill in H361. At least that's how we introduced it. Otherwise, known as police oversight.
Mm-hmm.
And that we were mindful that Burlington's charter change was going to be on the table as well at the same time. So that's that one. And then, of course, there's work that we're seeking to do in to kind of complete it's an act relating to establishing the Office of Health Equity within the Department of Health, which really is the completion of that work. The appropriations was already there in a position we're actually actively interviewing currently as we speak right now. But it also, I'll just leave it there instead of getting into too many bushes.
Okay.
And then there's H 357. H 357 does it's an act relating to the Office of Racial Equity.
Mm-hmm.
That we're hoping to expand the authority and create some independence for Susanna's office. And what other goodies do we have for you today? There is I promise there's only 2 more left. There's a bill called H 38, which is an act relating to adding new positions to the Human Rights Commission. We are supportive of that. I think Tom Stevens is the sponsor there from appropriations. I think that's about $800,000. And the final one is and this is mostly because we were hoping to use 25% of the cannabis excise taxes for community reinvestment in marginalized communities.
Mm-hmm.
And we're hoping to get it into H 321, which is in play right now.
Okay.
I think the biggest highlight that I wanted to shine was 382 as it pertains to
Right.
the data across the criminal
Right.
justice system. Thanks for the time.
Thank you, Mark, very much. Yeah, it's hard not to listen to we have a bill to increase the staffing at the HRC, which was in the report, my God, years ago. I don't, whatever. All right. Glad someone's moving it. Thank you. Can I ask everyone to look at these as well, please? Okay. Same process, but we'll talk about it again, these in April. I don't know what'll happen between now and then. The planet could tilt over on its axis like Uranus. So but please let's get this going. This is, again, it is not a perfect system, but it allowed us to do something this session. And from what I'm hearing from people, there seems to be a bit of a disturbing, I guess now I would say, trend that last session community members weren't called, and it seems like we're doing it again now, even after I don't know how many attempts at an intervention that have been made about this issue with them. Uh we'll try again. We'll see what happens. I will get in touch with Martin Lalonde. The other things that you need to know for April are that both the Crime Research Group and the DRJS are supposed to speak with us, and I'm working on figuring out how we're going to do that in 2 hours. And do this. I will figure it out. Please bear in mind, I might actually ask that we start that meeting at 5:30 rather than at 6. Because there's a lot here. I wouldn't ask if it weren't the session, but we really need to be on top of this as much as possible. I think even if they don't somehow get us to testify, it's important to have positions on these things, because there will come a time where we can speak about this. It'll be a little off topic, but that comes to another issue, which I'll bring up right now, but I want you to think about it, and then we'll have a bit of a discussion about it. One of the issues is, we're required to write a report biennially. We submitted one in 2024 and that was off the schedule, but they had asked for 3, count them, 3 other reports between the report before that and the one that we submitted last year. So I was like, guys, we're going to have to take another year on this one. And they were like, okay. Part of my idea is, because I've been sort of polling people slowly, is in fact to resubmit the last report. I think it makes a statement. These issues are still out here. I would submit it with a cover letter from us explaining why we are resubmitting it. And it would have to, some of these things haven't changed, right? Mark was just talking about, here we are, we're still talking about staffing the HRC fully. Still. This came up, I don't even remember when this first came up anymore. Mark, when did this come up? This came up in like 2017, didn't it?
I think it was 6 or 7 years ago, I think.
Yeah.
Or maybe at least.
That's it. Thank you. It's enough. And so I'm feeling like there's a certain performativity to the gesture that may be instructive. Think about it. I like it, obviously, but that doesn't mean that we are going to do it. I just thought I'd bring this forth precisely because so many of these things just don't get done. I mean, there's so much you can do. There's so much you can point out. If someone's not reading what you're pointing out, then why rewrite it? You know, I could use bigger words. I mean, seriously? I mean, that's just an issue. So that will be a discussion that will start now and go forward. Okay? Any other issues anyone wants to bring up?
Hey, Tom, this isn't really an issue and it's more of a logistical thing, but I was just wondering if whoever is like the owner of the Zoom link or whoever, like if there can just be like a reoccurring calendar invite sent out with the link. I know it's the same link, but so it's marked in calendars for the remaining of the year. That's at least
Sure.
helpful for me to have in my schedule so this doesn't sneak up on me. I know it's the second Tuesday. I recognize that.
No. I'm just surprised that's not happened for you.
I mean, I don't have it. Maybe somebody else does, but I'm also new to this group.
I asked for you in specific because you were new, and
Thank you.
I will. I'll do that again. Maybe I'll do it myself. Okay.
Happy to help if you need assistance.
Thank you.
You're welcome.
Well, I think we've got that.
Okay. Thanks, Eitan.
Absolutely. Anything else, anyone? Okay. Be aware emails are going to start coming, I hope, fairly quickly because people will want us to do what we are supposed to do by statute. We will see. So I will be in touch that way. You know the good night, Mark. You will know that we're gonna the action items. Please look over these bills, make your comments, get them to me. That's what you need to do next. Okay. The other thing would be the completion of the draft of the bill regarding God, I'm brain dead. I'm sorry.
The impact assessment.
Thank you. And that's it for right now. For right now. Anybody got anything else? Got that, Jessica. Okay. Have nice dinners.